Hi guys, welcome to my YouTube channel.
I had to put on my reaching hat. Hear me out.
I think we should first go through the issue of the state's motion. There was a request in the motion for an expedited hearing on that. I'll ask you, Mr. Pryor, did you receive a copy of that motion?
I did not. If Mr. Evans would like to cite the case and the case law and the statute that grants the court authority to hear Ms. Shiflett, by all means go ahead. But if he's going to regurgitate things that have happened that are clearly inadmissible, we're going to have a problem. And I'm going to strongly oppose this, going down this path at this point.
I understand, Mr. Pryor, and I think to correct you, it was the affidavits, not of Summer Shiflett. She hasn't submitted any affidavits.
Mindy Gee, Judge.
And there was a objection made based on hearsay, and I am going to consider that objection and hear and rule on that before we get into what Ms. Gee has to say in her affidavits or what Ms. Shiflett is alleged to have said to Ms. Gee. So I would like to hear, Mr. Evans, there's an objection to those affidavits requesting the court not consider them based on hearsay. And what is your response to the hearsay objection?
Your Honor, it doesn't go to the truth of the matter asserted. Also, she just wants to talk to the court. That's the bottom line.
Who does?
Ms. Shiflett.
Your Honor, I've got to object to the representation of what Mrs. Shiflett has allegedly said to this Mindy Gee, now attempting to come in through Mr. Evans. I mean, we now have multiple levels of hearsay here. And quite honestly, this motion it was identified 10 to 14 days ago. Forgive me, I don't remember the exact date. Mr. Evans, in his own argument, has had plenty of opportunity to attempt to contact Summer Shiflett or even opposing or Mr. Garrett Smith. And it doesn't appear that there were any efforts to do that prior to the hearing 2 days ago. And so again, if we're going to make statements regarding what somebody said to somebody, again, additional problems.
All right.
And Judge, if I could just add that even if Mr. Evans wants to suggest he couldn't go to get a hold of Ms. Shiflett because of Mr. Smith, we have a subpoena process. And I would assume the two lawyers from the state would understand that they have every right with 2 weeks notice to subpoena any witnesses that they feel would help their case.
And counsel, please, again, we're only on an issue here of do these affidavits contain hearsay? You'll have plenty of time for other argument on the other bigger issues here, but keep it confined to that. Mr. Means, what's your response to the state's indication that there's an exception that would apply?
Thank you, Your Honor. And looking at these affidavits, there's not a lot of difference between the two of them. I think we do have a problem where we have hearsay and then we have double hearsay. And I think the analysis would have to be provided at both levels. I think the present sense impression does not apply, to be quite frank. And trustworthy, I think we have an issue because I don't even think these could be characterized as midnight affidavits, considering this is after the fact of the hearing. This is more of the morning after. So I think trustworthiness is an issue as the prosecution attempts to be coming kind of in a backdoor manner to address what should have been addressed at the hearing 2 days ago.
All right, thank you, Mr. Means. Your response, Mr. Pryor.
Judge, I'll start with the last one, which would be the catch-all, which is usually a tactic used in court to try to get something in when there's no other reasonable reason to get it in. So that's not applicable in this particular case, and really quite honestly goes to more authentication. The present sense impression, Judge, that's taught in first-year law school, and that's an impression that someone gets upon observing a startling event. And quite honestly, Judge, there's been 14 days for Ms. Shiflett to do this. To suggest that after 14 days we've had a startling event that warrants her to come forward with something is ludicrous. So quite honestly, I can't even by the minimum stretch of my mind imagine any situation where present sense impression would even remotely apply to this. They are grasping. And now I know why they're grasping, because it took a significant amount of time for them to come up with a response while we patiently waited for them to address the hearsay issue. This is hearsay. It doesn't come in. And Judge, again, I guess yesterday I was temperate. and I was upset, and I'm still that way. And I want to apologize to the court for that, because I don't mean to be, but this is a very disturbing situation, and to suggest that it's present sense impression is just completely ridiculous. And again, I apologize to the court for my temperament.
All right, I've reviewed it. The statements of Mindy Gee about what she did in terms of taking a phone call are not hearsay. That's her own testimony in the affidavit that's sworn. However, these statements as to what Summer Shiflett told Mindy Gee, that Mindy Gee is now telling the court, is clearly hearsay. And so the court will not consider and will strike those portions of both affidavits that pertain to any statements made by anything that Summer Shiflett did say. All right, with that in mind then, Mr. Evans, would you continue with argument in support of your motion to allow the testimony of Summer Shiflett?
Your Honor, yes, we've found no rule for the court to disallow further evidence in a hearing. This is not a trial. This is just a hearing. There's nothing that says the court has to follow timeframes, especially if the result is a manifest injustice. We believe that the record that the court's trying to rely on is going to be entirely empty of the facts that go to the heart of the issue. And the heart of the issue for the court is, did Mr. Wood's communication with Ms. Shiflett, were those influenced, and that led to her changing her testimony to law enforcement? So we believe that her testimony is absolutely crucial. She is the person that we're talking with in all of these matters, and she wants to testify, and we ask the court to allow her to do so.
Again, I think the argument is well off of what the motion that is before the court. The only, if we can even call it a rule that applies, is they cited Idaho Rule of Professional Conduct 4.2 entitled Communication with Persons Represented by Counsel. There is nothing express or implied in that rule that allows the court to entertain this motion.
Mr. Wood, at the time, through his counsel, chose yesterday at a trial not to present any evidence. Now, at this point, at the last hour before we make closing argument, this is an attempt to get information in through the back door. And that backdoor process is going to be violative of my client's right to a fair opportunity to present his argument here. Because, Judge, if you allow Summer Shiflett in, I am going to be compelled to ask the court to continue ruling on this motion so that I can bring Mr. Smith back, put him back under oath, and offer rebuttal testimony for Mr. Smith to counter whatever Ms. Shiflett says, or to concur with whatever Ms. Shiflett says. And I don't know what Ms. Shiflett says. I haven't heard from Mr. Smith whether Ms. Shiflett even has legal counsel. And if she has legal counsel, Judge, Mr. Smith needs to be present for that examination. And quite honestly, if they're going to be allowed to reopen something that this court closed, and they have cited no rule that allows them to reopen this, other than a professional conduct rule, which is totally inapplicable, they shouldn't be allowed to do this.
Thank you for the response, Mr. Pryor. Mr. Evans, rebuttal argument.
Your Honor, just one clarification. If you look on paragraph 10, let me just be clear what the state's wanting to do. So moves this court to allow contact with Ms. Shiflett. The court knows bar counsel was called with this. So the prosecutor's office contact with Ms. Shiflett and are allowed to testify in the court. So Rule 4.2, if you look at the very bottom, that is the state asking to contact her. And so how do we do that when they have been represented by an attorney? You need to get permission from the lawyer, if she still has one, or authorized to do so by the court. So that was done with bar counsel, and that's what the motion is. So it's the state to communicate with her as well as her to communicate with the court. Thank you.
At this time, for purposes of the hearing today and our closing arguments, I am going to deny the motion to allow the testimony of Summer Shiflett. So the evidence submission is still closed, although we do have the arguments that have been submitted, which will be considered. So that'll be the court's ruling on the motion. This time then we'll proceed with our closing arguments.
Judge, I think there's a misunderstanding by counsel for Mr. Wood. The basis for disqualifying a prosecutor is conduct. It's not the impact that it has on the witness, but rather its conduct. And I can't see in any situation where suggesting that someone's a wimpy person or looked like he was about to pee his pants are not disparaging remarks. I can't see where calling Mr. Means incompetent is not a disparaging remark to a material witness. It's egregious. It is incredibly egregious. I cannot think of any situation that is more egregious than a prosecuting attorney who would go in and interview a witness and for 20 minutes not interview the witness, but rather offer a monologue of what his theory is in the case, disparage counsel, disparage the defendant, and manipulate. The expert on case law, the expert on authority, what did he say that was compelling? He said, he, meaning Mr. Wood, got caught. Now, getting caught is not the term you use unless either you're fishing or you're lying or you're cheating. And Mr. Woods is cheating, Mr. Wood is lying, and Mr. Wood is doing nothing but trying to influence, coach, intimidate a witness before that witness has had a chance to get in front of a trial. I don't have any other recordings other than Zuluma Pastenes. And I'll be going through that, and we may be revisiting some issues once I've had a chance to go through that in the final interview with Ms. Pastenes. But I don't have any other tape recordings. But what I do have is an interesting thing that occurred. And I know this court wasn't part and parcel of the preliminary hearing back in August of this year. But I had an opportunity during that preliminary hearing to talk with Ms. Gibbs while she was on the stand. And I was questioning her about what she knew, what the prosecutor had said to her. And after I asked her what the prosecutor had said to her, Judge, she immediately turned on the camera and looked directly in Mr. Means's eyes. And I said right after that, why were you looking at Mr. Means?
Your Honor, I'm going to object for hearsay.
This is argument, Judge. This is argument. This isn't the presentation of evidence. I understand, but you're still referencing a specific comment someone made out of in a separate proceeding. I think that's hearsay.
Okay. Now, obviously, I've been verbose, and I've been verbose in the past, and the court has been very patient with me. Judge, the totality of the circumstances are this. We have one of the biggest trials in the state of Idaho, and people are watching this with attention that I can't even fathom. We are all under the gun, and we are all being watched very carefully. And any first-year attorney who's going through law school is entrusted by ethics and taught about ethics, that these are the things you do not do. And Mr. Wood has been practicing for a while. He has told me before that I did plenty of defense work. I'm a prosecutor now. And Judge, for the record, he also told me on 2 separate occasions.
Your Honor, objection for hearsay.
Sustained.
I can't think of a more egregious situation other than a prosecuting attorney in one of the most high-profile cases in the state of Idaho, and I could argue, Judge, in the United States. I don't know how many people are watching me right now or watching us right now, but I would imagine it's significant. And this prosecutor, with full knowledge and at the expense of Fremont County, chose to fly out to interview a witness and suggesting that it was going to be a meet and greet, and then spends 20 minutes of a narrative doing everything he can to influence this witness to testify a certain way. We will never know the extent of what this prosecutor has committed in this particular case. And I can't think of any better reason to disqualify him than the fact that we don't know what else he has done. And quite honestly, Judge, anything he says about what he has or has not done, I have very little faith in anything Mr. Wood will say. And at this point, I will defer to counsel.
Obviously, I concur with Mr. Pryor on his points made. Does the court want me to go ahead and attempt to argue some of the points made by the state's brief that was filed this morning as well in the closing, or do you want to save that for rebuttal, Your Honor?
I'll leave that up to you, Mr. Means.
Thank you. I just, in trying to organize my thoughts and present it in a more efficient manner, overall, the motion doesn't introduce anything that wasn't presented at the trial in this matter, but to assist the court in the finding that Mr. Wood should be disqualified from this action. In summary, Your Honor, when you look at the recording and you read the transcript, I think the initial impression is red flags are raised, eyebrows are raised. When you listen to it again, I think it becomes quite a bit more disgusting. When we look at here in a summary, you have Mr. Wood admitting on this recording that he was in Hawaii at the time that Mrs. Daybell, was arrested. He was in Arizona at the time that these statements from these witnesses were taken. I still have yet to try to figure out why he's present at any of this. In addition, when this tape was discovered, I served on December 17th, and this is part of the record that is readily available for everyone, a specific set of discovery requests to the prosecutor's office asking what contact this prosecutor's had with all of these witnesses, and I listed some specific witnesses. Discovery responses were due to that specific request by January 2nd. That's the 14-day limitation according to the rule, Idaho Criminal Rule 16. It's expressly set out there. I'm going
to object. I just don't remember any discovery things being brought up in the hearing.
Well, there's a separate issue out there, Mr. Means. I think, correct me if I'm wrong, did you file a motion to compel?
I did file because it's now time to file that motion to compel. But why this is, sorry, Your Honor, I don't mean to.
I'm just going to say that's not being heard today. If there's a need for hearing a motion to compel and you still don't have responses and think that needs a hearing, sure, we'll get that scheduled and take that up at another time. So go ahead and move on.
Thank you, Your Honor. No, it's important to context this entire conversation that Mr. Wood is having with Ms. Shiflett, having this knowledge here. I think it's an important factor for the court to consider when it's analyzing coercion and manipulation.
I'm going to take a break for about an hour, and then we will come back on the record at 4:30, and I'll make a decision at that time. In this case, then, we're dealing with the comments that were made to a potential material witness who is the sister of the defendant, Lori Vallow. And as Mr. Evans pointed out during cross-examination, this witness may or may not ever be called to testify at a trial. So that's something I have to consider. The prosecutor, based on these allegations, could, of course, choose to recuse himself, but there's been no indication that he is doing that. Mr. Woods could, if the allegations were true, be charged under that statute of Idaho Code 182604. There's no evidence or indication that that has happened. There could be a sanction issued by the Idaho State Bar, and their sanctions may include a private reprimand, a public reprimand, a suspension of license, or disbarment. Those are possibilities out there. There is no evidence before the court that the bar has taken any such action. So without knowing whether or not this potential witness will ever be called to testify at a trial, the court cannot find at this time that the interaction between Mr. Wood and the witness would render Mr. Wood's continued participation in this case unfair, and cannot determine that the prosecutor's pretrial activity will be a material issue in this case. For those reasons, then, the motions to disqualify Mr. Wood are denied. Now, if Ms. Shiflett in the future is called to testify at trial in this case, the court would require a pretrial hearing based on the evidence I heard at this hearing, which has been referred to as a taint hearing, and that was done in the case of State versus Severson, 147 Idaho 694. It's discussed in Head Note 46. So I would require that type of hearing before her testimony based on the evidence been presented by the defendants in this case. The court at this time has no other information of any other such conversations that may have occurred with other potential witnesses. If they did occur, then there may be a possibility of a future request for additional taint hearings for those witnesses as well. But that's not an issue before the court, as the only information submitted was the transcript and recording of the conversation with Ms. Shiflett. So finally, there were some concerning things in the recording in regards to the derogatory comments made by Mr. Wood about Mr. Means. I'm not going to issue an order to apologize or anything to that effect, but it's certainly my practice to always encourage a civility amongst counsel in my cases, and I'll just leave it up to Mr. Wood to determine whether or not he thinks that is an appropriate thing to do in order for continued civility and professionalism going forward in this case. Finally, of course, if the Idaho State Bar were to take any action, this court would be advised of that by the State Bar Association, and this issue may be subject to being reopened for further findings and conclusions if I received any such information. But any decision regarding a sanction for any violation of the ethical rules, if they did occur, is left to the sound determination and discretion of the Idaho State Bar. So that will be the court's ruling on these motions.